Alex here with part 130 of the My Docket series on child custody and visitation. As with my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We're going into the order denying my motion to modify child support. This is what we were waiting for. I knew it was coming, but I didn't know quite when in the My Docket series it would come. Because I like to give dispositive orders their own separate video, and we don't have any ancillary documents in this video, it should be a pretty short video. I haven't read the order denying ahead of time, but I am going to read it with an eye towards appealing. I do file an appeal on this order denying. However, as mentioned earlier in the series, I didn't have the money to pay the filing fee or the bond, and so it ends up getting dismissed for non-payment of the filing fee or the bond. We can talk a little bit more about that when we actually get to the Supreme Court's order on it, because I have quite a big opinion on this action that was taken. I think at this point in time, with every 10th video, I also like to let my viewers know, because I do get messages on this occasionally. If you're not getting all of the email notifications from YouTube on the My Docket series, it's probably because you have subscribed to the channel, but you have not clicked on the bell notification button. So make sure you go ahead and click on that bell notification button if you actually want to get all the notifications rather than just the ones that YouTube's algorithm decides to send you. Okay, now at this point in time, we can go ahead and take a look at what the judge has filed. Here we have the order denying motion to modify child support. First thing the judge does is go into a summary introduction, which is that he has reviewed my motion to modify child support, my ex's opposition, and my reply to her opposition. I have submitted the matter to the court for consideration. What he means by that is I filed a request for submission. He's now going to find an order as follows. This is pretty much right here a summary factual statement. We share a common minor child, born September 13th, pursuant to the court's order after hearing filed October 19th. We share joint legal and joint physical custody, my ex having our son from 12:30 p.m. on Sunday until 3 p.m. on Wednesdays, etc. This is the visitation schedule. He goes into child support. Pursuant to stipulation and order, it was set to, $148. We agreed that since my ex provides health insurance, even if we didn't agree, a statute forces this to occur, just to let you guys know. Anyway, we agreed to have my ex provide health insurance, and she gets a downward deviation, half the premium amount, which reduces her child support to $73.91 per month. I submitted the matter for decision on June 28th. Neither of us had filed a financial disclosure form. He then follows up with ordering us to provide financial disclosure forms on July 5th. Okay, that's exactly what I just stated. He ordered us to provide those forms. On July 25th, we appeared before court on the order to show cause hearing. We discussed the pending motions. Next assertion is I resubmitted the matter. In the motion to modify child support, I claimed I was working full-time 2011. Claimed that in February 2012, the firm I worked for dissolved and was sued. That's true. Claimed that I obtained work June 2012 as a paralegal. Claimed this is substantially less than my previous job. In actuality, guys, the wage is the same. I don't know why he's saying this, unless he's either not paying attention or he's trying to sabotage this case. But $15 an hour is, if I remember correctly, the same wage, if not higher. The reason I was earning less is because the commission from the previous job. And even then, that commission wasn't throughout the entire time I was there. It was only high in November and December. Sometimes I don't know if this judge isn't listening or if he's just playing dumb. As in, he's acting like he doesn't know what's going on, but he really does. It's one or the other. Next assertion is claiming that I am taking advantage of working part-time to increase my student enrollment. That's true. I contend that because my income has decreased more than 20%. Sometimes I feel like I say 40%. If I ever have said that before, I meant 20. I'm not sure. Anyway, my income has reduced more than 20%, so review is mandatory, not just appropriate, but mandatory. There's a statute that says so. So anyway, I contend that I am not willfully underemployed as I'm working part-time, not for the purpose of avoiding the payment of support. This is good that he's stating at least my argument correctly. I mean, sometimes I wonder if he even gets that right. I'm attaching copies of recent paycheck stubs to my motion. I didn't file a financial disclosure form with the motion. Yes, I did. I don't know why he's saying that. This was filed. If you go back into my docket series, you'll find this document. So I'm not sure what he's talking about. In opposition, my ex contends that I am willfully underemployed as I admittedly did not see other work, either in legal capacity or in web design. She argues that I have opted to pursue my education, claims that I have provided no report of money received designing websites, argues that many pursue education while providing for their children. This is okay, I've talked about this before. This is a policy argument. You can't use this. So if you want to learn why you can't use arguments like this in court, you need to watch two videos. The first one is policy versus the law, and the second one is statutory construction. The Supreme Court of Nevada has repeatedly stated that policy arguments are unavailing in the face of an unambiguous controlling statute. And the reason why is because the policy arguments that are being asserted have already been debated in the legislature. It is not the role of the attorneys in the courtroom to debate policy, with some exceptions. The policy is debated by the politicians we elect. So the Republicans, the Democrats, the other parties, they go before the legislature, they go into these debates and they decide how to fashion the law, or specifically how to fashion a statute. Once that statute has been fashioned, the debate is over, and it is the role of the courts to interpret and apply existing law. The legislature made it clear you can reduce your income as long as you're not doing so for the purpose of avoiding child support. In my particular case, I went above and beyond, and I decided to reduce my income so that in the future I would have a higher income. Anyone who goes to college is not typically thinking, I'm going to spend 4 years going to debt to get a job that pays less. People who go to college are thinking they're going to get a job that pays more. That's kind of the point. I'm not sure if there's anyone out there that really wanted to put all that money and time into something just to come out worse than if they hadn't gone in the first place. So this isn't a total, like, a strange, bizarre idea. If anyone watched the hearing video, you'll recall that he tried to make my argument into something like, well, somebody could go on vacation or go to the Louvre and all this other weird stuff that he came up with. None of that stuff is actually relevant in this case. And then she also states that she should not have to underwrite my education by paying more child support. The thing that makes me mad about this is the same lawyer who will argue the exact opposite given another client. She will have another client who's going to school and she will argue the exact opposite thing. I've talked about this before. I sometimes feel like these attorneys have multiple personality disorder, where they have like 15 or 16 different simultaneous personalities with different positions. It's really frustrating too, because as some of my viewers pointed out, my ex actually also goes through a decrease in income. And if you looked at my last video, you will see an email from her stating that she went through a decrease in income. So these arguments actually endanger her, because I could later on use judicial estoppel against her. So like, say in the future, so she does ultimately win this and I'm not able to appeal it because I can't pay the filing fee. But say in the future, my ex decides to go to school and to lower her income so that she can get an education. Now she's screwed by her own attorney, because I could use judicial estoppel against her to block her from taking an inconsistent position in the case. So sometimes attorneys like this will get so caught up in their win-at-all-cost strategy, that's a video topic by the way, that they will inadvertently hamstring their own client, because later on their own client will need to take an inconsistent position. I wonder sometimes if attorneys like this realize this or not, because I do recall after I get primary physical custody that my ex either loses her job or quits her job and decides to do something else. And she doesn't try to modify child support, but maybe it's because she realized she couldn't. Because if my ex did try to modify child support, I would use her own arguments against her. If you want to learn how to do this to an attorney, please watch my video, Judicial Estoppel. It's also called the estoppel of inconsistent positions. Anyway, I'm going to move on. Next assertion. Makes argues that if I wanted to pursue an advanced degree, I could do so by taking online classes. This is a lie. Night class is wrong. Weekend class is wrong. Continue to work full time simultaneously, maybe. It's possible, but very difficult, and in fact does damage a person's grades. Usually, a person can't do both simultaneously. I guess it's possible that some people can. So anyway, you guys would have gone through the affidavit filed by my professor and academic advisor, and he states in his affidavit that online courses, night classes, and weekend classes are not available. Next assertion is, on reply, I claim that my current income as a paralegal debt collector is commission-based. Okay, so he does know this, and that even if I was imputed to that position full-time, I would still have a significant reduction in income, which is also true. I claim that I have earned $800 in building websites, but that I will not find professional employment. Okay, so if a judge seriously does not understand that you cannot get a degree, that you can't get a job in computer science without a degree in computer science, then something is wrong with him. But I think we've already established going throughout this case that something is wrong with him. We just don't know what it is. But this is not like, you can't just say, hey, I made some websites, hire me, to a company like Amazon or Microsoft or YouTube, or, these are full-blown professional software engineering positions. Making a website for somebody on the side is not the same as going through school and learning about data structures, analysis of algorithms, mathematics of computer science, software engineering techniques, design patterns. These things are more than just making a website. There were some classes towards the end that, they have most of the classes at UNR had nothing to do with building websites. In fact, now that I sit here thinking about it, I can't remember a single one that did. Anyway, I'm going to go ahead and move into the next section. I claim that I've been seeking alternative employment in the legal industry. I claim that the perils of changing employment prevent me from leaving my current job. This is, again, very obvious. If you talk to ordinary people and ask them, hey, what do you think about leaving this job for another job? One of the first things you consider is, number one, what if it doesn't work out? What if I leave this job for another job and something goes wrong? Now I don't have any job. This is totally normal. You can't just point the finger at a father who's going through a child support case and say, you can go get that better job. It's easier to say that, but to actually go through the anxiety of it and the transition is a complete different story. It's one thing to get fired on purpose. It's one thing to quit your job because you don't feel like going to work. But just asking people to switch jobs and go into particular fields as if we can just do that, as if you can just show up at a place and say, hey, I want to work here, hire me, and now you have to hire me. It's like they almost have to bend themselves into these impossible logical pretzels just to get their argument to fit through. It's I guess they call it trying to fit a square peg in a round hole. In any event, let's move on. At the hearing, July 25th, I argued that by obtaining a bachelor's degree, I would be able to provide better for my child. Just let me state this right now to you guys, that my income has quintupled. So that's exactly what happened. I was making a certain amount then, and I'm making 5 times more now. So exactly what I said would happen, did happen. Next section here. I claim that I'm not able to work full time because my classes are only offered during the daytime hours. This is true. I claim that my current work hours is 30 per week at the rate of $15 per hour. So I'm working part-time. It's not even like I'm working 20 or 15 hours. I'm working 30. And it's like still not good enough for him. Next assertion here. And this is why people come up with, okay, I need to stop again for a second. If anyone wants to know why the MRA groups, men's right activist groups, and why what's the other group? I guess they call it Red Pill. There's another group even. There's a third group, the MGTOW groups. If anyone wants to know why these groups are gaining popularity, it's not so much the nonsensical arguments by the attorneys and even the exes that's causing these groups to gain, popularity and credibility. It's the judges who are buying the arguments, hook, line, and sinker. And it's the gender bias, if you want to, you can take a look at my video, gender bias, that actually makes people not only suspicious, but flock to those organizations. So one of the first things that I think, I don't even need to go into one of the first things. The judge just needs to follow the law because the statute already says that he's not allowed to do what he's trying to do. So, they could start with following the actual law that's been enacted by the legislature, and then we can get into more complicated things. Once they learn how to do that simple thing, we can get into more complicated things after that. Next section here. On September 19th, I filed a notice of academic advisor's affidavit, Dr. Michael of Arrington University academic advisor, and then it goes into all the things that he has stated. Okay, additionally, a court cannot modify, A court cannot modify child support if the predicate facts upon which the court issued the order are substantially unchanged. The modification has to be in the best interest of the child. Okay, this second section here I'm suspicious of. Because the first section here controls So the law controls what child support is supposed to be, and it's presumed that the law is what's in the best interest of the child. So it's almost like he's trying to say here that maybe he's allowed to violate the law because there's a different law, which it's a violation of statutory construction. If you want to learn more about how the court is supposed to interpret two statutes that appear to conflict, please watch that video, because it's actually one of the strongest ways that you can win an appeal, is using statutory construction. Next assertion here is the law sets the obligation of support for one parent at 18%. Pursuant to the law, notwithstanding the formula set forth, the minimum amount of support can be $100 per month. I don't know why he's mentioning that. Next section here is when we share joint custody, we use a formula, and that is known as the Wright v. Osborne formula. Next section here goes into willful underemployment. Presumption arises that underemployment is for the purposes of avoiding support. Once the presumption arises, the burden of proving willful underemployment for reasons other than avoidance shift to the supporting parent. So this is exactly what happened at the hearing. I state that I chose to take advantage of the reduced number of hours that I was working by enrolling in additional classes to obtain a bachelor's degree. I claim that I'm actively seeking additional employment, but also indicate that I'm not working additional hours, and claim that I can't find employment in my desired field without obtaining a degree, which is true, which again I did after I got my degree. I provided the court with no evidence regarding my attempts to locate further employment to support my current part-time employment. Father has provided the court with no evidence that I'm unable to secure additional paid employment in my current desired field. The court finds that I have failed to demonstrate a good faith effort to find additional employment. Yes, he could get that, but he still has to defeat the purposes of avoiding underemployment, which would be going to school. So he's trying to use this paragraph here to satisfy the first analytical prong. The first prong is to show willful underemployment, which I can give him, because I did argue that even if I was willfully underemployed, I was willfully underemployed for the purposes of getting a degree, which is a valid legal argument. Next section. My explanations admit willful underemployment. This assumption raises the presumption that underemployment is for the purposes of avoiding support. While my decisions may be admirable, they are also voluntary. Parents have a legal obligation to support their children. The court is unpersuaded by my argument that my personal education pursuit is in our... What? Whoa. This should be quoted and put into an article or something. So this judge is saying that going to school and actually getting your degree and multiplying your income by 5 times is not in a child's best interests. That's a bold statement to make. It's actually shocking to me right now as I read that. This is definitely appealable. Anyway, I did file an appeal, and we'll talk about more about that. I just can't even believe I'm reading that right now. The judge is unpersuaded that a personal education pursuit is in the child's best interests. I mean, what else can you do with that? I'm going to move on now. Just a little, usually they'll say things like this, but they'll deny it to put it in writing. Wow. In any event, I guess it's good that he is no longer running for election. I'm just going to move on. I mean, that's sad that a judge has stated that. All right. A court is unable to modify child support based on pure speculation. Yeah. It's like he didn't even read the transcripts. Wow. All right, guys. I mean, this is the court system that we live with. Moving on to the next section. My justifications for underemployment are insufficient to prove that willful underemployment is for the reasons other than avoidance of child support. Wow. It really upsets me that I couldn't get this appeal to go through. It's a disappointment, because I would have loved to see this one thump him on the head. I'm just glad I'm done with this guy. I mean, I don't know. I mean, you can't even reason with him. It's like the logic center of his brain has been rotted away. I mean, it's just, I read stuff like this and then I realize why he ordered midnight exchanges for a 2-year-old. It's just not even, it's just so, there's no way to justify it. It's just weird. The guy's weird. Anyway, moving on to the next section. Yeah. Okay, so I provided documentation demonstrating a reduction of income of more than 20%. My testimony reveals that employment part-time, working less than 40 a week. So what he does is he imputes it to 40. Based on evidence presented, I've not demonstrated that I'm incapable of working full-time. Yeah. You know, guys, you guys, I mean, as the public, we have to purge the benches of judges like this. We just have to do it. I mean, it's just egregious. So anyway, he imputes the income and then he uses that as the basis to deny modification. I'm going to just go ahead and wrap this video up. It's really sad to see something like this because, I mean, I knew he was bad, but I didn't know that was the reason that he used. That's a really messed up reason. Okay, certificate of service by mail under Rule 5, so I'm done with that. And I think that's it. So I filed a motion to modify child support. The district court has disposed of that motion by denying it. Going into the aftermath, I filed, wait, in this video I filed nothing, so I incurred $0 in costs. My ex's attorney filed nothing, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney, I'm inclined to put this at $0 because she doesn't have to do anything. But she does have to review it, put it into her system, contact my ex. So I guess 15 minutes for a document like this, especially because it's in the child custody case, is justified. 15 minutes at the rate of $250 an hour is going to come to $62.50 in attorney fees for my ex. As with my previous videos, feel free to take this. Feel free to post any questions you have down in the comments below, and I will see you guys next time.